Case 1. Stephany Elizabeth Bilecki, also known as Stephany LaFontaine, September 14, 2017, Anchorage Superior Court, 3rd Judicial District, State of Alaska. There are cases that change the way a community thinks about the people living right next door. Cases that remind investigators, prosecutors, and ordinary citizens alike that the most important work in child protection does not happen in courtrooms or police stations. It happens in neighborhoods, in schools, in the quiet moments when someone decides to ask a question that nobody else was willing to ask. In Alaska, a state where communities are often separated by hundreds of miles of wilderness, where families rely on one another in ways that cities rarely require, the systems designed to protect the most vulnerable members of society carry an enormous weight. When those systems work, children grow up safe. When they fall short, the consequences can be devastating, and the cases that result from those failures become part of the permanent record of what a community chose to see and what it allowed itself to miss. This is one of those cases, and it begins not with a dramatic arrest or a public scandal, but quietly, the way the most devastating cases often do, with a loss that looked, on the surface, like a tragedy no one could have prevented. Stephany Elizabeth Bilecki was born and raised in Alaska. By the time she became a mother, she appeared to those around her to be a normal young woman navigating the ordinary difficulties of early parenthood. She was known to her neighbors, her family, and her community. She was not, on the surface, someone who raised alarm bells. That surface, investigators would eventually discover, concealed something that no one around her had been willing to see. In the fall of 2015, Stephany Bilecki's first infant daughter passed away. The child was very young, still in the earliest weeks and months of life, a time when the world is entirely new and entirely dependent. When emergency responders were called and medical professionals assessed what had happened, the initial conclusion was that the infant had passed from natural causes. Sudden infant death, sometimes called SIDS, is a documented and medically recognized phenomenon. It is every parent's nightmare and every pediatrician's most dreaded conversation. When no clear cause of death can be immediately identified in a very young child, SIDS becomes the explanation that both medicine and grief reach for first. So the passing of Stephany Bilecki's first daughter was recorded. The family mourned. Life continued, and Stephany Bilecki remained in the community, and in time, she had another child, a second infant daughter. Investigators who would later review this case described what came next as one of the most sobering sequences of events they had ever documented. In 2017, less than 2 years after the loss of her first daughter, Stephany Bilecki's second infant daughter also passed away. Once again, the child was very young. Once again, the initial presentation suggested a natural passing. But this time, something shifted. When medical examiners and law enforcement reviewed the circumstances surrounding the second infant's passing, they began asking questions that had not been asked, or not asked with enough persistence, the first time. The proximity of the two losses, both infant daughters of the same mother, both in similar circumstances, triggered what investigators in Alaska described as a deeper and more comprehensive review. What that review uncovered was not a tragedy. It was a pattern. Medical examination of the second infant revealed findings inconsistent with natural causes. Examiners determined that the child had been intentionally suffocated. That finding sent investigators back to the loss of the first daughter in 2015. When that case was reopened and re-examined in light of new information, examiners reached the same conclusion: intentional suffocation. 2 children, 2 separate incidents, 2 losses that had each, in isolation, been allowed to pass without criminal consequence. It was only the second passing that broke the silence the first had been buried under. As investigators built their case, they executed a search of Stephany Bilecki's digital records. What they found on her devices became one of the most significant pieces of evidence presented to the court. Among her internet search history were queries that prosecutors described as deliberate and specific, including searches for ways to cause a person's passing without leaving detectable evidence. Those searches were documented, analyzed, and placed before a jury as evidence of premeditation and intent. The prosecution's case rested on 3 pillars: the medical findings from both infants, the digital search history, and the pattern of conduct that connected both losses to the same individual. Stephany Bilecki was charged in connection with both children's passing. She faced the full weight of Alaska's criminal justice system. The trial, which unfolded in Anchorage Superior Court in the 3rd Judicial District, drew significant attention from child welfare advocates across the state. Victim advocates who attended the proceedings described the evidence as some of the most difficult they had ever witnessed presented in a courtroom. The children, both girls, had never had the chance to walk, to speak, to know the world beyond the walls of the home they shared with their mother. When the verdict came, the court found Stephany Elizabeth Bilecki guilty. At sentencing, the court handed down a term of 130 years, with 30 years suspended, meaning Bilecki faced 100 years of actual incarceration. It was a sentence that reflected not only the severity of what had been done, but the extraordinary breach of trust involved. These were not crimes committed by a stranger. They were committed in the most private and protected space in a child's world: the home, the crib, the arms of a mother. The case prompted renewed conversations across Alaska about the protocols surrounding infant passing reviews and the importance of thorough investigation even when initial findings suggest natural causes. Child welfare organizations pointed to the Bilecki case as a sobering reminder that protective systems must remain rigorous, especially in cases involving repeated childhood tragedies within a single family. For the two daughters Stephany Bilecki brought into the world and chose to take from it, there would be no more springs in Alaska, no first steps, no voices learning their own names. Their stories ended before they truly began. But through the work of investigators, medical examiners, and prosecutors who refused to accept coincidence as an explanation, those stories were heard in a court of law. Justice, however long it took to arrive, arrived. If you or someone you know has concerns about the welfare of a child, the Child Help National Child Abuse Hotline is available 24 hours a day, 7 days a week, at 1-800-4-CHILD. Every call can make a difference. If this story moved you, please take a moment to like this video, leave a comment below, and make sure you are subscribed to Cold Case Hour so you never miss an episode. Your support keeps this work going. Case 2. Heather Alexie, 2025, Fairbanks North Star Borough, 4th Judicial District, State of Alaska. There are communities across Alaska where the winters are long and the distances between neighbors can stretch for miles. Fairbanks sits in the interior of the state, a city accustomed to isolation and self-reliance, where families build their lives against a backdrop of extreme cold and vast wilderness. It is a community that takes care of its own, where a welfare check is not a bureaucratic formality but a genuine act of concern, one neighbor reaching through the silence to ask if another is all right. In 2025, a welfare check in Fairbanks led authorities to a scene that would deeply trouble even the most experienced first responders. What they found at the residence would launch a criminal investigation, a multi-day search, and a prosecution that brought into sharp focus some of the most difficult intersections in the justice system: mental health, substance use, parental responsibility, and the protection of children who cannot protect themselves. Heather Alexie was a resident of Fairbanks, a mother with a young son. Her son was 6 years old, an age full of wonder, full of questions, full of the particular brightness that belongs only to children who have just begun to understand that the world is wide and endlessly interesting. He was, by any measure, at the beginning of his life. When concerned individuals in the community requested a welfare check at the family's residence, officers from the Fairbanks Police Department responded. What they encountered upon arrival were visible injuries on the 6-year-old boy, injuries that, according to law enforcement accounts filed with the court, were consistent with physical harm. The child's condition was serious enough that the situation was immediately escalated and emergency medical services were called. As first responders worked to assess and respond to the child's condition, investigators turned to locate Heather Alexie. She was not at the residence. By the time law enforcement understood the full scope of what had occurred at that address, Alexie had already left Fairbanks. According to information provided to the court, she had traveled south to Anchorage, putting nearly 360 miles of Alaska wilderness between herself and the scene investigators were now processing. The search for Heather Alexie involved coordination between the Fairbanks Police Department and law enforcement authorities in Anchorage. Alaska state troopers were also involved in the effort. The manhunt lasted for a period of time before Alexie was located in Anchorage, and placed under arrest by authorities. The charges brought against her were serious. Prosecutors in the 4th Judicial District filed a charge of second-degree murder in connection with the passing of her son. Second-degree murder under Alaska law requires proof of knowing conduct, that the individual understood their actions created a substantial risk of serious harm and consciously disregarded that risk. As the case moved through the early stages of the legal process, information began to emerge about what Alexie had reportedly told investigators. According to accounts provided to the court and reported by Alaska news organizations covering the arrest, Alexie told law enforcement that she had developed beliefs about her son, specifically, that she believed he was not her child at all, but a supernatural entity. She reportedly described experiencing hallucinations that led her to believe the boy was what some indigenous and regional belief systems refer to as a skinwalker, a malevolent spirit taking the form of a person. Mental health professionals and defense attorneys in Alaska and across the country have long grappled with cases in which individuals experiencing severe psychotic episodes commit acts they would never commit in a stable mental state. The presence of reported hallucinations and irrational beliefs in a criminal case does not eliminate legal culpability, but it does place enormous demands on prosecutors, defense counsel, and the court to carefully examine the individual's mental state at the time of the offense. For the child at the center of this case, a 6-year-old boy in Fairbanks who had done nothing to invite harm, who had only ever been a child trying to grow up in a difficult world, the question of his mother's mental state was not the only question that mattered. There was also the question of the systems around him, the checks, the oversight, the community networks that exist precisely to catch children before they fall through the cracks. The case remained in active proceedings as of early 2026. No verdict had been reached, and the legal process was continuing through the 4th Judicial District. All charges against Heather Alexie are allegations that must be proven in a court of law, and she is presumed innocent until and unless the court finds otherwise. What is not in dispute is that a 6-year-old boy in Fairbanks, Alaska, did not survive. A child who should have had decades ahead of him, school years and summer afternoons, and the slow, wonderful discovery of who he was going to become, was gone. His name deserved to be spoken with care. His story deserved to be told with the seriousness it warranted. Alaska's legal system and its community mental health infrastructure continue to face the challenge of identifying parents in crisis before those crises become tragedies. Advocates working in the field of child welfare across the state have pointed to the Fairbanks case as a reminder that early intervention, whether through mental health services, community support, or family networks, can sometimes be the difference between a family that receives help in time and a family that becomes a court case. The court will determine what accountability looks like for Heather Alexie. What the community must determine is what it is willing to invest in the systems that might prevent the next case from following the same path. In honor of the 6-year-old boy whose life was taken far too soon, and in recognition of the work that remains to be done, this case will continue to be followed as it moves through Alaska's courts. If this case has left you thinking about the children in your community, please reach out to the Child Help National Child Abuse Hotline at 1-800-4-CHILD. Awareness and action save lives. Don't forget to like this video, leave your thoughts in the comments, and subscribe to Cold Case Hour. There is more coming, and every subscriber helps this channel continue telling these stories. Case 3, Kelsey Jackson, March 13, 2019, Anchorage Superior Court, 3rd Judicial District, State of Alaska. The parking lot at Point Woronzof sits at the western edge of Anchorage, where the land meets the waters of Cook Inlet, and the skyline of the city falls away behind you. On clear days, Denali is visible in the distance, the great mountain standing above everything, a reminder of the scale and indifference of Alaska's wilderness. It is a place where people come to look out at the water, to think, to breathe. It is not a place where anyone expects to find what Anchorage Airport Police found on the morning of March 13, 2019. Officers responding to the area discovered a vehicle in the parking lot. Inside that vehicle was a mother and her 3-year-old daughter. The mother, Kelsey Jackson, was alive but had sustained wounds consistent with a suicide attempt. Her daughter, Brooklyn Jackson, 3 years old, still in her car seat, still strapped in the way a careful parent straps a child in, had been subjected to multiple stab wounds and had not survived. The scene that confronted investigators that morning was one of the most painful in the Anchorage Police Department's modern case history. Brooklyn Jackson had been 3 years old. She had been a child who still sat in a car seat. She had been someone's daughter, someone's grandchild, someone's entire world, a little girl in the first bright years of her life. And she had been harmed in the one place a child is supposed to be most safe, buckled in, cared for, in the company of her mother. Kelsey Jackson was transported to a medical facility for treatment of her injuries. As she recovered, investigators began the process of building an understanding of what had happened in that parking lot and what had led to it. The investigation required a careful examination of Jackson's mental health history, her personal circumstances at the time of the offense, and the events of the days and hours leading up to March 13th. What emerged from that investigation painted a portrait of a woman in profound crisis. A mother whose mental health had been deteriorating, whose substance use had compounded her instability, and who had arrived at a breaking point that the systems around her had not detected in time to intervene. Defense attorneys who later represented Kelsey Jackson in court would emphasize these factors, not to excuse what happened, but to explain the context in which it occurred and to argue for a sentence that recognized the role of untreated mental illness in the tragedy. Advocates working with families in crisis across Alaska pointed to the Jackson case as a painful reminder that maternal mental health, including postpartum depression, psychosis, and the compounding effects of substance use on cognitive function, represents a public health challenge that the criminal justice system alone is not equipped to fully address. The best outcomes in cases involving mentally ill parents, those advocates argued, come from early identification and intervention, not from waiting until a crisis has already become a catastrophe. Those conversations, however important, could not change what had happened to Brooklyn Jackson. In September 2021, more than 2 years after that morning at Point Woronzof, Kelsey Jackson entered a guilty plea to a charge of second-degree murder. As part of the plea agreement negotiated between the defense and the prosecution, the charge of first-degree murder, which had also been filed, was dismissed. Second-degree murder under Alaska law reflects the legal finding that the act was knowing and that the individual understood the risk their conduct created, even if the specific intent required for first-degree murder was not established. In February 2022, Kelsey Jackson appeared in Anchorage Superior Court for sentencing. The courtroom that day held family members, victim advocates, and members of the public who had followed the case since its beginning. The weight of what was being addressed in that room, the passing of a 3-year-old girl, the sentencing of her mother, was not lost on anyone present. The court sentenced Kelsey Jackson to 20 years in prison, to be followed by 10 years of supervised probation. The sentence reflected the court's consideration of multiple factors: the severity of the harm done to Brooklyn, the role that mental health and substance use had played in the offense, and the legal framework within which second-degree murder is sentenced in Alaska. For the family of Brooklyn Jackson, no sentence could close the wound that her passing had torn open. Brooklyn was 3 years old. She had a name. She had a face. She had preferences and small joys and the particular laughter that belongs only to very young children discovering the world. She deserved to grow up. She deserved decades she never received. And the people who loved her carried a grief that sentencing guidelines cannot quantify. The Anchorage Daily News, which covered the case extensively from the initial discovery through the sentencing hearing, noted that the case had prompted renewed calls from child welfare advocates and mental health professionals for expanded services for mothers and families in crisis. Services that might provide an off-ramp before a family reaches the edge of the kind of desperation that leads to outcomes like the one at Point Woronzof. Brooklyn Jackson was 3 years old. She mattered. Her story is told here so that she is not forgotten, and so that the conversations her case demands continue to be had in Anchorage, in Alaska, and across the country. The court has spoken. The sentence has been handed down. But Brooklyn's legacy, if she is to have one, lies not in the punishment of her mother, but in the commitment of communities to ensure that the systems meant to protect children are funded, staffed, and responsive enough to reach families before it is too late. Please take a moment to like this video and subscribe to Cold Case Hour. Leave a comment below. Your engagement helps this channel continue bringing these important stories to light. Case 4. Marley Marque, 2020, Anchorage Superior Court, 3rd Judicial District, State of Alaska. In the early hours of a day in 2020, Anchorage police officers encountered a woman at a gas station who was behaving in a manner that alarmed bystanders and prompted an emergency call. The woman was Marque. Her behavior at the gas station, which included, according to law enforcement accounts, threatening conduct toward officers, led to her immediate detention. It was what officers discovered after detaining her that transformed what had initially appeared to be a mental health or public safety call into a homicide investigation. When officers went to the Anchorage residence associated with Marque, they found the body of her 5-year-old son, Job. He had not survived. The child's cause of death was determined through forensic investigation, and the findings were presented to prosecutors who then brought the full force of Alaska's criminal code to bear on the case. Job Marque was 5 years old. 5 years old means starting kindergarten or thinking about it. It means learning to read the first letters of your name. It means being exactly old enough to understand that the world is full of things you haven't seen yet, and young enough to believe that you have all the time in the world to see them. 5 years old is a beginning, not an ending. And yet for Job Marque, it was both. The investigation into his passing was extensive. Prosecutors in the 3rd Judicial District of Alaska built a case that they argued demonstrated not merely reckless or negligent conduct on the part of Marque, but deliberate, first-degree murder, the intentional taking of her child's life. That distinction matters enormously in Alaska's legal framework. First-degree murder requires the prosecution to demonstrate that the act was premeditated and intentional, that the individual had formed the conscious purpose of causing a person's passing and then acted on that purpose. Marque faced that charge. She faced it through a legal process that lasted several years, from the initial arrest in 2020 through the trial and its conclusion. The length of time between an arrest and a final verdict in a first-degree murder case is not unusual. These cases are complex. The evidence must be meticulously prepared and presented, and both the prosecution and the defense are entitled to the full process the law provides. When the verdict was returned, the court found Marque guilty of first-degree murder in the passing of her son Job. In February 2024, nearly 4 years after Job's passing, Marque was brought before Anchorage Superior Court for sentencing. The courtroom that day included representatives from the Anchorage District Attorney's Office, members of the defense team, and, in spirit if not always in presence, the memory of a 5-year-old boy who deserved to be alive. The court sentenced Marque to 50 years in prison. 50 years is a sentence that reflects the court's determination that what happened to Job Marque was not an act of impulse or mental collapse. It was a deliberate choice. A choice that ended the life of a child who had no say in the matter, who had done nothing to deserve harm, and whose only relationship to Marque was that she was his mother, the person the world had designated as his primary protector. Alaska law enforcement officials who worked the case expressed, in statements following the sentencing, their relief that the process had reached its conclusion and that Job's passing had been met with meaningful accountability. Investigators who had walked into that Anchorage residence and found him there carried what they found for a long time. Cases involving children always do that to the people who work them. Victim advocates in Anchorage pointed to the Marque case as an example of the legal system working as it should, not perfectly, not quickly enough to save a child, but responsibly and thoroughly in the aftermath of an act that the community refused to allow to pass without consequence. For Job Marque, there is no perfect justice. There is only the recognition that his life had value, that his passing was not invisible, and that the people responsible for it were held accountable by the courts of the state where he lived and lost his life. He was 5 years old. He mattered. He is remembered here. The court's verdict and sentence stand as the record of what the state of Alaska determined about the value of Job's life. That record exists so that his story is not erased, and so that the communities and systems around families in crisis understand the stakes of the work they do every day. If this case has left you wanting to do something, consider supporting child welfare advocacy organizations in your state. Children like Job depend on communities that take that responsibility seriously. Please like this video, subscribe to Cold Case Hour, and leave a comment below. Every view and every subscription helps this channel continue shining a light on the cases that matter most. Case 5, Ashley Ard, 2013, Anchorage Superior Court, 3rd Judicial District, State of Alaska. There are cases that become something larger than themselves, cases that move out of the courtroom and into the national conversation, cases that become the subject of documentaries and debate, and the kind of long, public argument that communities have when they are not sure what justice looks like. The case of Ashley Ard is one of those cases. Ashley Ard was a resident of Eagle River, a community north of Anchorage, a mother in a situation that she had kept secret from almost everyone around her. In 2013, her newborn infant was found by authorities under a tree in the area near her home. The infant had not survived. What followed was a legal process that would last several years, generate intense public attention, and eventually produce both a verdict and a documentary. One of the rare occasions when a criminal case from Alaska found its way into the national media spotlight not because of its scale, but because of the questions it raised about justice, evidence, and the particular vulnerability of women who find themselves facing criminal charges in the context of a secret or undisclosed pregnancy. The circumstances surrounding the infant's passing were, from the beginning, contested. Prosecutors in the 3rd Judicial District argued that Ashley Ard had deliberately caused the death of her newborn, that the infant's placement under a tree was not the desperate act of a woman in shock, but a deliberate decision to abandon a living child in conditions that would cause the child harm. The prosecution built its case around the infant's condition, the physical evidence at the scene, and Ashley Ard's behavior in the period surrounding the birth. The defense offered a fundamentally different account. Ashley Ard maintained that her pregnancy had been concealed from her family, from those around her, and to some extent from herself in the way that some women experiencing unwanted or frightening pregnancies find ways to deny or compartmentalize what is happening to them. The defense argued that the birth had been a traumatic and disorienting experience, that Ard had been alone and in crisis, and that what prosecutors were framing as deliberate harm was in reality the tragic consequence of a woman who had been overwhelmed in a moment of extreme physical and psychological distress. These competing narratives, the prosecution's account of intentional harm and the defense's account of a traumatic birth gone wrong, sat at the center of one of the most heavily scrutinized trials in Anchorage Superior Court in the 2010s. The trial took place in 2016, 3 years after the infant was found. The delay between the initial discovery and the trial was a function of the investigation's complexity and the legal preparation required on both sides. When the proceedings finally concluded, the court found Ashley Ard guilty of second-degree murder. Second-degree murder under Alaska law does not require proof of premeditation in the way that first-degree murder does. It requires the prosecution to demonstrate that the individual acted knowingly, aware that their conduct created a substantial and unjustifiable risk to a human life, and choosing to disregard that risk. The jury's verdict represented their determination that the evidence met that standard. The case did not end with the verdict. Several years after Ashley Ard's conviction, her story became the subject of a documentary investigation, a production that examined the case from multiple angles and raised questions about the evidence that had been presented at trial, the handling of certain forensic findings, and the broader legal and social context in which prosecutions involving undisclosed pregnancies and infant deaths occur. The documentary was titled Accused, A Mother on Trial, and it introduced the case to an audience far beyond Alaska. Documentaries of this kind do not constitute legal proceedings. They cannot overturn convictions or compel retrials. But they can, and sometimes do, contribute to post-conviction legal proceedings by shaping public awareness of contested evidence or procedural concerns. As of the time of this documentary's production, Ashley Ard remained convicted of second-degree murder in the passing of her newborn infant in Eagle River. The case raises questions that the justice system continues to grapple with in cases involving undisclosed or concealed pregnancies. How does the law distinguish between an act of harm and an act born of overwhelming crisis? How does a jury weigh forensic evidence against the lived reality of a woman in extreme distress? And what does justice look like for an infant who never had the chance to be named, to be held, to be known by the community that later debated the circumstances of its passing? Those questions do not have easy answers. What is certain is that the child at the center of this case, a newborn, hours or days old, found under a tree in Eagle River, Alaska, deserved more than the beginning it received. Whatever the full truth of that morning in 2013, The infant's passing was a tragedy that the law ultimately found to be a crime. Ashley Ard was held accountable under that law. The conversations her case generated about how the justice system handles the most vulnerable moments in women's lives are part of the ongoing effort to ensure that accountability is not only consistent, but fully just. For viewers who want to learn more about this case, the documentary Accused, A Mother on Trial is available on Investigation Discovery and presents multiple perspectives on the evidence and the verdict. Please like this video, subscribe to Cold Case Hour, and leave a comment sharing your thoughts on this case. These conversations matter, and your engagement keeps this channel alive. Case 6, Winona Fletcher, 1985, Anchorage Superior Court, 3rd Judicial District, State of Alaska. There are cases that do not resolve cleanly. Cases that begin in one era, extend across decades, and ultimately force the legal system to revisit decisions made in a different time under a different understanding of the law. The case of Winona Fletcher is one of those cases. It begins in the summer of 1985 in Anchorage, Alaska, when a 14-year-old girl became involved in a series of events that would result in 3 people losing their lives, and in Fletcher herself spending the majority of her life inside Alaska's prison system. To understand this case fully, it is necessary to hold 2 truths at the same time. That 3 people lost their lives in a horrific and preventable set of circumstances, and that the individual convicted in connection with those events was 14 years old, a child, in the most literal legal and developmental sense of the word. In the summer of 1985, Winona Fletcher was a teenager in Anchorage. The details of what took place that summer, as documented in court records and reviewed by the Alaska Supreme Court in the decades that followed, involved Fletcher's participation in a triple homicide. She was arrested, charged, and prosecuted in a system that in 1985 had very different tools, very different legal standards, and a very different understanding of adolescent brain development than the system that would revisit her case 40 years later. Fletcher was convicted. She received a sentence that, in practical terms, meant she would spend decades, potentially the rest of her life, in prison for actions she had participated in at the age of 14. She was, at the time of her conviction, the youngest person in Alaska's legal history to be convicted of murder. In the decades that followed, the legal landscape around juvenile sentencing underwent a fundamental transformation. A series of landmark decisions by the United States Supreme Court addressed the constitutionality of certain sentences imposed on juvenile offenders. The court's reasoning drew heavily on a growing body of scientific research demonstrating that the adolescent brain, particularly the regions governing impulse control, risk assessment, and the ability to weigh long-term consequences, is neurologically incomplete. Adolescents are not, the science established, simply small adults making adult decisions. They are individuals whose brains are still in development, whose capacity for the kind of fully formed moral and rational judgment that we hold adults to is genuinely limited by biology, not merely by character. Those rulings did not free juvenile offenders. They did not erase convictions. But they did establish that sentencing structures which treated juvenile offenders identically to adult offenders, without any consideration of their age and developmental stage, could in certain circumstances violate the constitutional prohibition against cruel and unusual punishment. Winona Fletcher's case eventually came back before Alaska's courts in light of these evolving legal standards. The review process was lengthy. These reviews always are, because they require not just legal analysis, but a willingness to revisit painful events and painful verdicts that communities had long since put to rest. In September of 2025, a court resentenced Winona Fletcher to 60 years. The resentencing represented a reduction from the original sentencing structure under which she had been held. It reflected the court's application of the evolved legal standards governing juvenile sentencing to a case that had originated 4 decades earlier. The families of the 3 individuals who lost their lives in 1985 had been part of this story for 40 years. For them, the resentencing was not a cause for celebration. Their loved ones had not been brought back. The harm that had been done to their families had not been undone. Whatever the legal and scientific arguments about juvenile brain development, the fact of 3 lives ended in the summer of 1985 was immovable. Their grief was immovable. Winona Fletcher, now a woman in her mid-50s, had spent nearly her entire adult life incarcerated. Whatever she had been at 14, Whatever combination of circumstances, environment, trauma, and incomplete brain development had placed her in the middle of a triple homicide, she had lived the consequences of that summer for 4 decades. The case remains one of the most complex and contested in Alaska's legal history. It does not lend itself to simple moral conclusions. What it does, with extraordinary clarity, is illustrate the profound difficulty of administering justice across time, of reconciling the demands of accountability with an evolving understanding of culpability, development, and the limits of what incarceration can accomplish. The 3 individuals who lost their lives in 1985 deserve justice. They received it, as the law of their time defined it. Whether that justice was complete, proportionate, and fully aligned with what we now understand about adolescent development is a question that Alaska's courts spent 40 years working through. It is a question without a clean answer. But it is a question that matters, for the victims whose lives were taken, for the juvenile offenders whose lives were defined by their worst moments before their brains were fully formed, and for the communities that must decide what justice is for. Please take a moment to like this video and subscribe to Cold Case Hour. Your comments and engagement help this channel continue covering the cases that challenge us to think deeply about justice, accountability, and the law. Case 7, Stephany Hamburg, 2017, Anchorage Superior Court, 3rd Judicial District, State of Alaska. There is a category of child welfare case that does not announce itself with an emergency call or a dramatic discovery. It unfolds slowly, invisibly, behind closed doors, over days and weeks and months. A quiet and sustained failure of care that ends not with a sudden event, but with a child who has been depleted, weakened, and ultimately overwhelmed by the absence of what every child needs to survive. The case of Stephany Hamburg and her 2-year-old daughter belongs to that category. Stephany Hamburg was a resident of Anchorage, Alaska, a mother with a young child and a partner with whom she shared the responsibilities, or what should have been the responsibilities, of parenthood. Her daughter was 2 years old in 2017, an age at which children are entirely dependent on the adults around them for everything: food, safety, warmth, medical care, and the basic assurance that someone is paying attention to whether they are thriving. A 2-year-old cannot open a refrigerator and feed herself. She cannot assess her own nutritional needs or recognize when what she is being given is insufficient. She cannot walk to a neighbor's house or call for help or explain to the adults around her that she is not getting enough of what she needs. She is, in the most complete sense, dependent. And that dependency places an absolute obligation on the adults responsible for her care. That obligation was not met. Investigators who later examined the circumstances surrounding the passing of Stephany Hamburg's daughter determined that the child had been maintained on a diet consisting primarily of whole milk. In the nutritional and pediatric medical context, whole milk, while appropriate as a supplementary food for children over the age of 1, cannot serve as the primary or near-exclusive food source for a growing toddler. A 2-year-old child requires a broad range of nutrients, calories, proteins, and vitamins to sustain normal development and health. A diet consisting predominantly of whole milk is, over time, a diet that will produce malnutrition. That is what happened to Stephany Hamburg's daughter. Over a period of time, the child's nutritional intake was so inadequate that her body could not sustain its basic functions. She passed away as a result of malnutrition. Investigators and prosecutors faced a charge that reflected the nature of what had occurred. This was not a case of a single act of violence. It was a case of sustained, prolonged neglect, a failure to provide the fundamental care that a 2-year-old child cannot provide for herself. The charge brought was criminally negligent homicide under Alaska law, a charge that reflects conduct where an individual fails to perceive a substantial and unjustifiable risk that their behavior will cause serious harm. The word negligent does not mean innocent. Criminally negligent homicide in Alaska reflects the law's recognition that certain failures of care are so severe, so sustained, and so contrary to what any reasonable person would understand their obligations to be that they rise to the level of criminal conduct. A 2-year-old child cannot tell her mother she is hungry often enough, or urgently enough, or clearly enough to override the choices that adults make in a household. When those adults consistently make choices that deny a child adequate nutrition, the law holds them responsible for the consequences. Stephany Hamburg was convicted of criminally negligent homicide in December 2025. The conviction came after an extensive legal process that had begun in 2017 when her daughter passed away and that had moved through multiple stages of investigation, charging, and court proceedings over the years that followed. At the time of this documentary's production, Hamburg and her partner were scheduled for sentencing in April 2026. The full terms of her sentence were not yet determined, and this case remained in the final stages of the legal process. All information presented here reflects the public record as established through court proceedings in Anchorage Superior Court. The case prompted responses from pediatric medical professionals and child welfare advocates across Alaska, who emphasized the importance of regular well-child visits with medical providers. Visits that are specifically designed to catch exactly the kind of developmental and nutritional concerns that, identified early, can be addressed before they become tragedies. Pediatricians are trained to notice when a child is not gaining weight appropriately, when growth curves flatten, when a child appears underdeveloped for her age. Those visits exist as a safety net. For the 2-year-old girl at the center of this case, that net was not there when she needed it. She passed away from a cause that was entirely preventable, not by any extraordinary intervention, but by the simple, basic act of feeding a hungry child. She deserved that. Every child deserves that. Her passing, and the conviction that followed it, stands as a record of what the legal system determined to be a profound failure of the most basic parental obligation. That record exists so that her story is not forgotten, and so that the systems responsible for monitoring child welfare understand the weight of the work they do. If you have concerns about the nutritional welfare or safety of a child in your community, please contact the Child Help National Child Abuse Hotline at 1-800-4-CHILD. Every concerned call matters. Don't forget to like this video, subscribe to Cold Case Hour, and leave a comment below. Your support means everything to this channel. Case 8. Jackie Caswell. September 2025. Matanuska-Susitna Borough, Palmer Superior Court, 3rd Judicial District, State of Alaska. The city of Wasilla sits in the Matanuska-Susitna Borough, north of Anchorage, in a region of Alaska known for its wide valleys and the kind of community where people know their neighbors and watch out for one another's children. It is a growing community, a place where families have settled in increasing numbers over the past several decades, drawn by the landscape and the distance from the city's pace. In September of 2025, an event in Wasilla shook that community in a way that would result in serious criminal charges, a high-profile arrest, and a case that raised some of the most difficult questions a community can ask about what happens to the most vulnerable children inside homes where no one is looking. Jackie Caswell was a Wasilla resident in whose care a 4-year-old girl had been placed. The child was not Caswell's biological daughter. She was a girl entrusted to Caswell's household, dependent on the adults in that environment for her safety, her nutrition, and the most basic protections that a 4-year-old child cannot provide for herself. When authorities in Wasilla were called to the residence in September 2025, they found the 4-year-old girl in a condition that required emergency medical attention. Despite the efforts of first responders and medical personnel, the child did not survive. She was 4 years old. The investigation that followed was conducted by law enforcement authorities in the Matanuska-Susitna Borough in coordination with the state's criminal investigative resources. What investigators determined through that process formed the basis of a criminal complaint that was filed in Palmer Superior Court, the court serving the 3rd Judicial District in the Matsu Borough. Prosecutors brought serious charges against Jackie Caswell. The charges included second-degree murder and criminally negligent homicide, two separate legal theories that together reflected the prosecution's contention that what had happened to the 4-year-old girl in Caswell's care was not an accident and not the result of passive neglect alone. According to information filed with the court and reported by Alaska news organizations covering the arrest and initial proceedings, prosecutors alleged that the 4-year-old had been subjected to physical harm, specifically, injuries to the head consistent with physical force, and that she had also been systematically denied adequate food over a period of time. The combination of physical harm and nutritional deprivation, prosecutors alleged, had created conditions that led directly to the child's passing. The allegation of systematic food denial is one that child welfare investigators and victim advocates treat with particular seriousness. When a child in a household is specifically denied food as a pattern of behavior, not as a single incident of neglect, but as a sustained and deliberate practice, it represents a form of harm that is both physically dangerous and deeply corrosive to a child's sense of safety and worth. A 4-year-old who is hungry and afraid and has no means of communicating her situation to the outside world is among the most vulnerable human beings imaginable. As of early 2026, the case against Jackie Caswell was proceeding through the court system in the 3rd Judicial District. No verdict had been reached, and the legal process was continuing. All charges against Jackie Caswell are allegations that must be proven in a court of law, and she is presumed innocent until the court determines otherwise. The 4-year-old girl at the center of this case had a life that was just beginning. 4 years old means learning the names of colors, learning to count, learning what your own laughter sounds like. It means beginning to understand friendship, beginning to understand stories, beginning to understand that you are a person with a name and a place in the world. That life was ended before it had the chance to unfold. The Matanuska-Susitna Borough's Child Protective Services and law enforcement communities, in the aftermath of this case, face questions that every community faces when a child in a supervised or caregiving arrangement is found to have suffered serious harm. What are the monitoring requirements for children placed in non-parental care? What oversight mechanisms exist? And what can communities do to ensure that children who are placed in the care of individuals who are not their biological parents are not invisible to the systems meant to protect them? Those questions do not have simple answers. But they are the right questions to be asking, because the 4-year-old girl in Wasilla, Alaska, deserved to have someone asking them before September 2025. This case will be followed as it continues through Alaska's courts. Accountability, if the evidence supports it, will be the final chapter of a story that began with the passing of a child who deserved so much more than she received. Please like this video and subscribe to Cold Case Hour. If you are following this case and want updates as the legal proceedings continue, subscribing ensures you will see every new episode. Leave your thoughts in the comments below. Case 9, Tracia Hetty Jordan-Sainte, 2014, Anchorage Superior Court, 3rd Judicial District, State of Alaska. There are cases in which a child's survival is not the result of anything he could do for himself. Cases where the only thing standing between a child and a tragedy that cannot be undone is the arrival of someone else. Someone who notices something wrong. Someone who calls for help. Someone who gets there in time. In 2014, a 3-year-old boy in Anchorage, Alaska, survived because someone got there in time. His name has been protected in many of the accounts of this case, as is appropriate for a child victim, particularly one who survived and who deserves the right to grow up without his name permanently attached to the worst day of his young life. He was 3 years old at the time of the events at an Anchorage, and that would result in his mother, Tracia Hetty Jordan-Sainte, being charged with attempted murder and assault. The circumstances that brought Tracia Jordan-Sainte and her young son to that inn on the day in question were investigated thoroughly by Anchorage law enforcement. What officers and investigators determined was that Jordan-Sainte had made an attempt on the life of her 3-year-old son, an act that, had it not been interrupted or had the child not received immediate medical attention, would have resulted in his passing. He survived. That survival, the fact that a 3-year-old boy was alive to grow up, to eventually move past this moment and build a life beyond it, is the single most important fact in this case. It shapes everything that followed. The charges, the plea, the sentence, and the meaning of the entire legal proceeding. Tracia Hetty Jordan-Sainte was charged with attempted murder and assault in connection with what had happened to her son. The charges reflected the seriousness of what investigators had determined, that this was not an accident, not a moment of careless negligence, but a deliberate action directed at a 3-year-old child who had no capacity to protect himself. As the legal process moved forward, Jordan-Sainte's defense team and the prosecution engaged in negotiations that ultimately produced a plea agreement. Jordan-Sainte pleaded guilty to first-degree assault, a charge that, under Alaska law, reflects conduct causing serious physical harm to another person. The plea agreement resolved the more serious charge of attempted murder in exchange for the guilty plea to first-degree assault. In 2016, 2 years after the incident at the Anchorage Inn, Tracia Hetty Jordan-Sainte appeared before Anchorage Superior Court for sentencing. The court, having heard from both the prosecution and the defense, imposed a sentence of 15 years in prison with 8 years suspended, meaning Jordan-Sainte faced a term of 7 years of actual incarceration, to be followed by a period of probationary supervision. The sentencing in this case, as in many cases involving a guilty plea and mitigating factors, reflected a balance between the severity of the conduct and the circumstances that the court considered relevant to the appropriate length of incarceration. 7 years of actual prison time, followed by supervised release, was the court's determination of what accountability looked like in this specific case. For child welfare advocates who followed the case, the fact that the child had survived was a source of profound relief, and a reminder of why early intervention, community awareness, and systems designed to identify families in crisis matter so enormously. The boy at the center of this case was alive because someone was there. That someone, whoever they were, mattered. Mental health professionals who reviewed publicly available information about the case pointed to the importance of resources for parents experiencing crisis, particularly those dealing with untreated mental health conditions that can, in extreme circumstances, produce dangerous breaks from the kind of reasoning that most parents apply automatically to the care and protection of their children. The criminal justice system is not a mental health system, but the cases that come before the criminal justice system often reveal the consequences of what happens when mental health care is absent from a family's life when it is needed most. Tracia Hetty Jordan-Sainte was held accountable by the courts of Alaska. Her son survived. That survival is not the end of his story. It is the beginning of a life that, whatever its challenges, continues. He was 3 years old when his mother made a choice that could have ended everything for him. He lived, and in surviving, he represents the possibility that even the worst moments in a child's life do not have to define the whole of it. For the boy who survived, he deserved protection from the beginning. He received it, at least in part, when the help arrived in time. The systems that allowed him to survive that day are the same systems that communities across Alaska invest in when they fund child welfare services, crisis intervention, and mental health resources for families in distress. That investment is worth every dollar. Please like this video, subscribe to Cold Case Hour, and drop a comment below. Every piece of engagement tells the algorithm that stories like this one deserve to be heard. Case 10, Mechele Linehan, April 12, 1996, Kenai Peninsula Borough, Superior Court, 3rd Judicial District, State of Alaska. There are cases that enter the cultural memory of a place. Cases that become part of the way a community understands itself, part of the stories that are told and retold until they take on something larger than their original facts. In Alaska, the case of Mechele Linehan is one of those cases. It is a story that began in the spring of 1996 in the fishing community of Homer, unfolded through a murder investigation that sat dormant for nearly a decade, ignited into a high-profile prosecution in the 2000s, and ultimately resolved in a way that left many observers uncertain about what justice, in this particular case, actually looked like. Homer, Alaska, sits at the southern tip of the Kenai Peninsula, where the highway ends and the water begins. It is a small community, the kind of place where people know one another's names and stories, where the social world is compressed and the anonymity of a city is simply not available. In the spring of 1996, Homer was the setting for a love triangle that investigators would later describe as one of the most calculated and cold-blooded conspiracies in the state's modern criminal history. Mechele Linehan was 22 years old in 1996. She had come to Alaska, as many young people do, looking for a different kind of life, and she had found it, at least initially, in Homer, where she worked and socialized and moved through a social circle that included several men who were, to varying degrees, in love with her. Among them was Kent Lepink, a fisherman, a man who had developed deep feelings for Mechele and who had, by all accounts, believed that those feelings were reciprocated. On April 12, 1996, Kent Lepink was found in a remote area outside of Hope, Alaska, a small community on the western shore of Tunigan Arm, well outside of Homer. He had been shot multiple times and had not survived. He was 26 years old. What made the discovery of Kent Lepink's body immediately strange was a letter that Lepink himself had written before his passing, a letter that he had addressed to his parents and asked them to open only in the event of his death. When that letter was opened, it named Mechele Linehan as the person Lepink believed most likely to cause his passing. He had, in essence, written from beyond his own life to point investigators in a direction that they would eventually, though not immediately, pursue. The investigation in the aftermath of Leppink's discovery did not immediately produce charges. Mechele Linehan was interviewed by law enforcement in the period following the discovery, but no arrest was made. She left Alaska. She went on to build a different life. She became a wife and a mother, and an entirely different kind of person on the surface than the young woman who had been at the center of a murder inquiry in Homer a decade earlier. She attended nursing school. She lived in Washington state. She had children. For nearly 10 years, the case was open but dormant. In 2006, investigators working the cold case assembled a body of evidence that they believed was sufficient to support charges. Mechele Linehan, by then Mechele Hughes, married and living as a mother and healthcare worker, was arrested and charged with first-degree murder in the death of Kent Leppink. The prosecution's theory was that she and a co-defendant, John Carlin III, had conspired to cause Leppink's passing for the purpose of collecting on a life insurance policy for which she was named as beneficiary. The case against Linehan rested heavily on circumstantial evidence. The insurance policy, communications between Linehan and Carlin, and the account of events that investigators had reconstructed from witnesses, documents, and physical evidence gathered both in 1996 and in the decade that followed. There was no confession. There was no direct eyewitness to the act itself. In 2008, Mechele Linehan was convicted of first-degree murder. She was sentenced to 99 years in prison. Her co-defendant John Carlin III was separately convicted and sentenced. What followed was a prolonged series of appeals. Linehan's attorneys argued that the evidence presented at trial had been insufficient to sustain a first-degree murder conviction, that the circumstantial case assembled by prosecutors did not meet the standard required to establish premeditated intent to cause a person's passing beyond a reasonable doubt. Those arguments made their way through Alaska's appellate courts over the years that followed the conviction. In 2012, the Alaska Court of Appeals reversed Mechele Linehan's conviction. The reversal was based on the court's determination that the evidence presented at trial had been legally insufficient to support the verdict. Following the reversal, prosecutors in the 3rd Judicial District reviewed the case and determined that proceeding with a retrial was not viable. The charges against Mechele Linehan were dismissed. She walked out of the legal system a free woman, not exonerated in the sense of a formal finding of innocence, but freed by the determination that what had been presented against her had not met the legal standard required for conviction. Kent Leppink's family received no conviction. His letter, the letter he had written naming the person he feared, had been part of the public record for years. The fishing community of Homer, Alaska, where his story began, carried the unresolved weight of a case that had ultimately produced no final legal accountability. The Linehan case has been revisited repeatedly in true crime media. Documentaries, podcasts, and investigative articles have examined the evidence and reached varying conclusions about what the full truth of April 12, 1996 actually was. The legal record is what it is: a conviction obtained, an appeals court ruling that it could not stand, and charges ultimately dismissed. It is a case that illustrates the difference between what communities believe happened and what the legal system can prove happened, a difference that the law must respect even when the outcome feels, to some, deeply unsatisfying. Kent Leppink was 26 years old when he passed away on a remote road outside of Hope, Alaska. He had written a letter to his parents that he hoped would never be opened. It was opened. It named a name. And the legal system, after more than 15 years of work, ultimately could not make that name stick. His story is part of Alaska's history. The question of what truly happened on that spring day in 1996 belongs to the territory where the law ends and unresolved truth begins. This has been Cold Case Hour's documentary on the most haunting maternal crime cases in the state of Alaska. 10 stories, 10 legal records, 10 reminders of why the systems designed to protect children must be funded, supported, and treated as the urgent public priority they are. Every case in this documentary is drawn from verified court records, law enforcement accounts, and documented news coverage. This channel is committed to presenting true crime content with accuracy, dignity, and respect for every victim whose story is told here. If any of the stories in this documentary have raised concerns about a child in your life or your community, please reach out to the Child Help National Child Abuse Hotline at 1-800-4-CHILD. Available 24 hours a day, 7 days a week. The victims in these cases deserve protection. The best way to honor them is to build communities where the next child gets it. If you made it to the end of this documentary, thank you. It means everything to this channel that you were here for all 10 cases. Please take a moment right now to like this video. It takes 1 second, and it makes an enormous difference to how widely this content is shared. Subscribe to Cold Case Hour if you have not already, and ring the notification bell so you never miss a new episode. And leave a comment below. Tell us which case stayed with you, or share this video with someone who needs to see it. Cold Case Hour. Justice remembered. Truth told. Every case, every time.